RIDZWAN often annoyed ASMAH by sending texts and spamming calls to flirt with her after office hours. This incident often happened, causing ASMAH to seek the doctor's advice due to the pressure that she faced.
Sahira comforted ASMAH, who appeared to be sad. ASMAH started to tell the problem what had happened to her. ASMAH has strong evidence to be used as material evidence, so Sahira advised ASMAH to seek the legal advice about sexual harassment in workplace.
I'm going to present about facts of the case. In this case, Muhammad RIDZWAN bin Abdul Razak as the appellant and ASMAH binti Haji Muhammad Noor as the defendant are employees of Lembaga Tabung Haji. The respondent was subordinate of the appellant and reported directly to him. On 29 September 2009, the respondent made a complaint to the Chief Executive Officer that the appellant committed sexual harassment against him. An inquiry was conducted, and because there was insufficient evidence of disciplinary action, a strong administrative reprimand was issued to the plaintiff. On December 9, 2011, the appellant issued a arrest order against the respondent, seeking inter alia allegation that he did not commit sexual harassment against the respondent. Defendant filed his defense and also a counterclaim against the plaintiff. The respondent counterclaimed for damages based on sexual harassment, claiming general, aggravated, and exemplary damages. However, the High Court found that the plaintiff failed to prove his defamation claim against the defendants and allowed the appellant's counterclaim. It was upheld by the Court of Appeal, aggrieved the plaintiff appeal to the Federal Court.
Now we move to law applicable in the case. The Malaysian Federal Court, in the case of Muhammad RIDZWAN bin Abdul Razak versus ASMAH binti Haji Muhammad Noor, ruled that victims of sexual harassment will now be able to seek civil remedies under the tort of sexual harassment. This is the first case involving a sexual harassment victim at a workplace who sought remedy from the civil court that made the Employment Amendment Act 2012 into force. There was previously no avenue for civil action for sexual harassment under Malaysian law.
The case of Muhammad RIDZWAN Abdul Razak versus ASMAH Haji Muhammad Noor revolves around sexual harassment allegation and defamation. ASMAH accused RIDZWAN of subjecting her to sexual harassment in the workplace, including regular remarks, dirty jokes, inappropriate language, and repeated proposition to become his second wife. The Federal Court emphasized the importance of addressing workplace harassment and the legal implication of such behavior, emphasizing the need for clear boundaries and consequences for inappropriate conduct in professional settings. Muhammad RIDZWAN argued that ASMAH's complaint was false and damaged his reputation. The High Court dismissed the plaintiff's claims, allowing the defendant's counterclaim. The plaintiff appealed, arguing that the judge had incorrectly dismissed his defamation claim and accepted the defendant's counterclaim without sufficient legal basis or evidence.
The High Court rejected the appellant claim, ruling that the declaration of sexual harassment had been established. The respondent was awarded 2,000 ringgit Malaysia in offence and faultless damage, in addition to 100,000 ringgit Malaysia in general damage when the court entered a judgment on her counterclaim. The Code of Practice on Prevention and Eradication of Sexual Harassment in Workplace 1999 was amended as a result of it. Next, new provisions to address sexual harassment were added to the Employment Acts of 1995 by Act 2012, which also provide a new definition of sexual harassment.
Lastly, I will explain about the supported case applicable for the case of Muhammad Rizwan Abdul Razak bin ASMAH Haji Muhammad Noor. Based on the case of Muhammad Rizwan Abdul Razak bin ASMAH Haji Muhammad Noor, obscene and sexual charge were complained of by the defendant in sexual harassment in the form of verbal harassment under the Code of Practice for the Prevention and Eradication of Harassment Sexuality in the Workplace 1999. The court found that where acts of sexual harassment are so serious that they result in psychological effect on the victim, the act is summarized under the tort causing nervous shock with similar internationality as in the case of Wilkinson v. Downton. In the case of Wilkinson v. Downton, 1897, the court held that the plaintiff was entitled to recover in tort for the psychiatric illness she suffered as a result of the international act of defendant who knowingly and falsely informed her that her husband was injured in a road accident. The decision was relied upon in Clark v. Canada, 1994, which involved a similar situation. In the case of Clark v. Canada, the plaintiff sued for damage for wrongful dismissal due to sexual harassment, which led to her resignation. She experienced declining mental health and a lack of support. The legal case addressed liability from the employment relationship and tort liability under the Crown Liability Act and sought damage for the harm caused by the harassment. In that case, the plaintiff was sued the government and the provision of the Crown Liability Act considered were similar to those in our Government Proceeding Act 1956, particularly SS 5 and 6 of our Act. The court allowed the claim for damage for internationally causing nervous shock, similar to the tort in Wilkinson v. Downton. Based on both cases, there were a lot of similarity between the fact in Wilkinson v. Downton 1897 and Clark v. Canada 1994, and the fact of the case on appeal, there was more than sufficient evidence to show that the plaintiff did make vulgar and sexual-oriented statements directly at the defendant or within the presence of the defendant. In the case and the appeal, evidence showed that the defendant was emotionally vulnerable and affected by the plaintiff's objectionable remarks, leading to major depression diagnosed by a psychiatrist. Given that the plaintiff was aware of the defendant's fragility, the social harassment that was committed was deemed to be international cause of nervous shock. This resulted in the defendant experiencing significant emotional distress and leaving her job due to the stress caused by the harassment. So, the case of Wilkinson v. Downton and Clark v. Canada have supported the case of Muhammad Rizwan Abdul Razak v. ASMAH Haji Muhammad Noor.